Hello and welcome to the Minimum Competence episode for Thursday, January 15th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, offshore wind litigation, DOJ race relations agency reversals, Tesla's racism case mediation, and a wave of prosecutor resignations in Minnesota. Let's remember, progress is impossible without change, and those who cannot change their minds cannot change anything. And read today's legal news. On this day in legal history, January 15, 1970, the U.S. Supreme Court decided Williams v. Florida, a significant case interpreting the Sixth Amendment's guarantee of a trial by jury. The petitioner, Johnny Paul Williams, was convicted in a Florida court by a 6-member jury and argued on appeal that his constitutional rights had been violated because the jury did not consist of 12 members. The court, in a 6-2 decision authored by Justice Byron White, rejected this argument and held that the Constitution does not require a 12-person jury in criminal cases. The ruling marked a turning point in how procedural aspects of jury trials were viewed under the Constitution. Drawing on historical analysis and a functional reasoning, the court concluded that the number 12 was a historical accident rather than a constitutional mandate. It emphasized that what mattered was whether the jury could fulfill its essential purpose, promoting group deliberation, guarding against government overreach, and representing a fair cross-section of the community. The court's opinion opened the door for states to use smaller juries in certain criminal trials, leading to greater procedural flexibility. However, the ruling was not without its critics, including dissenting justices who warned that reducing jury size could dilute the quality of deliberation and increase the risk of wrongful convictions. The court later clarified in Ballou v. Georgia in 1978 that juries smaller than 6 members were unconstitutional, setting a lower boundary on size. Williams v. Florida continues to shape discussions around the structure and fairness of criminal jury trials. It reflects a broader judicial approach that balances historical tradition with evolving interpretations of fairness and efficiency in the criminal justice system. The decision also illustrates how constitutional protections, while deeply rooted, are not frozen in time, but subject to ongoing judicial scrutiny. On January 17th, a U.S. District Court will hear a request from Norwegian energy company Equinor to resume construction on its Empire Wind offshore project off the coast of New York. The company is suing the Trump administration after it suspended offshore wind development in federal waters, citing national security concerns related to radar interference. Equinor argues that the $4 billion project, now 60% complete, faces cancellation if construction doesn't continue by January 16th. The case follows a recent decision allowing Danish company Ørsted to resume work on its own halted project off Rhode Island. The legal challenge is one of several confronting the Trump administration's broader effort to stall offshore wind development. Trump officials have paused work on 5 federal wind leases, citing a classified Defense Department assessment. Offshore wind companies say these actions threaten billions in investment and the viability of long-term energy goals. Empire Wind is projected to power about 500,000 homes once completed. The Trump administration has reversed its decision to lay off nearly all employees of the Justice Department's Community Relations Service, or CRS, an agency created by the Civil Rights Act of 1964 to mediate racial and ethnic conflicts. In a recent federal court filing in Boston, the DOJ stated that it rescinded the September layoff notices issued to 13 CRS staff members, citing administrative discretion. Civil rights groups, including 2 NAACP chapters and the Ethical Society of Police, had sued to block the terminations, arguing they were part of an unlawful attempt to dismantle the agency. Though the employees have been reinstated, it remains unclear if they will resume work on CRS functions. The plaintiffs have asked the court to hold a hearing to determine the practical impact of the reversal and whether CRS operations will truly continue. Under the Trump administration, the CRS reportedly stopped accepting new service requests and faced budget cuts, with the current White House proposal offering no funding for it. However, a bipartisan appropriations bill in Congress would allocate $20 million to support the agency. Previously, U.S. District Judge Indira Talwani denied a temporary restraining order to stop the layoffs, but said the plaintiffs had shown a strong likelihood of success. She is still considering whether to issue a permanent injunction to prevent dismantling the CRS. Tesla has agreed to enter mediation with the U.S. Equal Employment Opportunity Commission, or EEOC, to try to resolve a federal lawsuit alleging widespread racial harassment at its Fremont, California factory. The EEOC claims Tesla allowed a hostile work environment where black employees were subjected to slurs, racist graffiti, including swastikas and nooses, and other forms of discrimination, some of which appeared on vehicles coming off the assembly line. Tesla has denied the allegations, arguing it was unaware of the conduct and accusing the EEOC of seeking publicity. U.S. District Judge Jacqueline Scott Corley approved a pause on some discovery deadlines to prioritize mediation efforts. The EEOC and Tesla are currently selecting a mediator, with talks potentially beginning in March or April. Both sides must report to the judge by June 17th if mediation fails. The lawsuit, filed during the Biden administration in September of 2023, is part of a series of legal challenges Tesla has faced over workplace issues at its Fremont facility. In a separate case, Tesla recently avoided a class action lawsuit when a California judge ruled that over 6,000 black workers at the plant could not proceed as a group, citing a lack of willing witnesses. 6 federal prosecutors in Minnesota resigned on January 13th in a move that may disrupt the Justice Department's intensified efforts to crack down on public benefits fraud, or alleged public benefits fraud. Among those stepping down are Joe Thompson, the former acting U.S. attorney for the district, and Harry Jacobs, a key figure in cases involving misused child nutrition program funds. Both were central to a high-profile Feeding Our Future investigation, which scrutinized alleged fraud in federal nutrition programs during the COVID-19 pandemic. Sources say the resignations were linked to political pressure from the Trump administration, including demands to investigate the widow of Renee Nicole Good, who was murdered by a U.S. immigration officer earlier this month. The DOJ reportedly declined to pursue charges against the officer, leading to internal dissent. Minnesota Governor Tim Walz condemned the resignations as evidence of the Trump administration's politicization of the DOJ, accusing it of forcing out experienced, nonpartisan staff. The departures come amid a broader exodus from the department, including 5 senior lawyers from the Civil Rights Division, which had worked closely with Minnesota prosecutors after the murder of George Floyd in 2020. Attorney General Pam Bondi recently announced a new DOJ fraud division and plans to deploy prosecutors from other regions to Minneapolis. The White House has also ramped up enforcement in other liberal-leaning districts, which has led to more prosecutions related to immigration protests and officer assaults, and in some cases, grand jury rejections of those prosecutions. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, he knows nothing and he thinks he knows everything. That points clearly to a political career.